Good morning, ladies and gentlemen. Thank you for coming. I can see from the profile of the attendees today that many of you are not here to learn the law, but rather who have questions to ask. So one thing I would like to announce is that whatever I'm going to show here on the slides will be available with the organizers. So if you really want to read about the rules and regulations in relations to takeovers, mergers, acquisition, general offer, delistings, exit offers, you can browse them through later so that, I leave more time for Q&A. Is that all right? All right. So, I think corporate actions, you have a very wide spectrum. So it's not meaningful if I were to go through every one that is not of topical interest. I think of late, what Singapore market has witnessed is that there are a number of privatizations, a lot of exit offers. And as David Gerald said, are these offers lowball? Are they fair to you if you bought in at a certain high price? And controlling shareholders, management shareholders, looked at current market, poor liquidity, poor valuation, high compliance costs, and then make a lowball offer. And invariably, these people, they have done their sums, they have done their math. They know that they are likely to succeed because they already have a certain block of shares which are significant, under their control. So what is left in the public float are you guys. And that is very easy to divide and conquer, plant the fear in you that, this is the last train out of the country. And if you don't take it, you'll be left alone. There's no more market. We are going to delist. You are going to be in a private entity where there's no market for your shares, And so while SIAS will do its part, will look out for, what are lowball offers, what are very complicated IFA reports that basically make no sense to the man in the street. Even the Securities Industry Council, which is a division under the MAS, they set guidelines. SGEC has also in regulators column set guidelines on the do's and don'ts in a takeover. Ultimately, a lot depends on you collectively as an investor. You must be an informed investor to decide to sell, to accept the offer, to vote for the exit offer, to vote for the delisting. You have to make an informed decision. And this is what it's all about. Because at the end of the day, Singapore is like any other dynamic capital market. Companies can come and list and delist. You can't have an impediment, a high threshold to exit, because then no companies will come here and list. And I don't think this is what the Singapore market regulators want to see. So you have to understand your own position. You have to understand your own rights. You got to read, you got to be an informed investor, informed shareholder before you make the decision to tick for or not to accept. So what I'm going to cover here are the usual things that you will encounter in the last 2 years. You see MGO's mandatory general offer, but I think increasingly more, it's the voluntary general offer, which is tied to delisting, tied to exit offer. So in order to be more complete, I've given a full spectrum of this. So I'm not going to spend too much time on this because I've given you the preface, and I think what is most important to you, as I've said, these things are going to be available if you ask the organizer, so if you can read it. So mandatory general offer is very simple. Someone who crosses 30% of the voting rights when they never had it. They have to make a mandatory general offer at the price that they cross 30%, right? Or if they have already crossed 30% but below 50%, then they have this creeping rule where they cannot acquire, they and their concert party cannot acquire more than 1% of the voting shares within a 6-month period. If they do so, they trigger an MGO, right? So that part, I think of late, we have not seen too many of these things. Voluntary general offer, this is what I think you see more recently, where they form a vehicle, they call it a SPV, special purpose vehicle, to make a bid to take the company private or to increase their shareholding, right? And so normally in such a case, if they intend to mount a voluntary general offer, they will set the acceptance level to 90% of the shares that did not control prior to the announcement of the offer. That is to exercise the, they call it the mandatory squeezed out compulsory acquisition. And I think we've seen some of this, or a number of these in recent cases. Partial offer used to be popular, but I think we hardly see that. Means people want to acquire a certain percentage. So, if they hold less than, X percent and they want to, launch a partial offer for less than 30%, it all has to be, all the following situations have to be subject to SIC's approval. So SIC will normally approve for less than 30%. Between 30 and 50, SIC will not approve as it will trigger an MGO. Above 50, SIC will approve under certain conditions. So all these things are, I'm going to skip this because this is not really of topical interest. I don't want to bore you. I can see some of you yawning. So, well, in a takeover situation, I think it's important that you read the offer document, right? But I think most of you, I can wager a bet that y'all will just look at the price. Don't care what the document says. You'll leave it to the regulator. But again, this is what has to be set out in the offer document, the terms, shareholding, dealings, and all that. But as I've said, to retail investors like you, what's the price? Will it increase or not? Did they make a no increase statement? What's going to happen? Can I call David Gerald and ask for more? So I think this is, of course, this is an important. We shouldn't belittle this concern, because at the end of the day, that's the reason that of your concern why general offer is low ball or fair and reasonable, right? So so of course when a takeover is mounted, the offeror issues an offer document. The target company's board of directors will come out with an offeree circular. So these are the things that will come out. What you should look for is, of course, the IFA's report. A lot of people have raised considerable public disquiet. Hey, what does the IFA report say? All technical jargon. Don't understand. What's fair? What's not fair but reasonable? What is so it has all this permutation, which you as I've set out on the slide, fair and reasonable. Okay, fine, fair enough. But is it fair to you, or fair in what context? Because you have to remember the IFA is talking about a lot of things, right? Okay, so what's not fair but reasonable? I think that people get stuck. How can it be not fair but yet reasonable? Not fair, not reasonable, fair enough means, likelihood is professionals are telling me not to accept, and the directors independent of the offer are telling me not to accept. Fair but not reasonable. Again, that is something that is puzzling. Fair but not reasonable. What does it mean? But this is what the structure is that is permissible for the IFA to opine. But of course, SGX has recently published a regulator's column, guidelines as to what the IFA must say, must do in order to give its professional advice. That one I will cover later, all right? Scheme of arrangement is like a takeover. Basically, it's like they form a vehicle, a new vehicle, and say that, well, in exchange for your shares, you take my shares, and then your listed company disappears. But then you have to vote for it, and that the required acceptance is they will call a general meeting, and if there are different classes of shareholders, most companies have only one class, but technically you could have companies which have preference shareholders, Series A, Series B, or whatever, and if they cannot be classified collectively as one block, then they got the whole different general meetings. And in each general meeting, the required acceptance level is majority in number of shareholders present and voting, representing at least 75% of the voting rights. So what does it mean? It means, for example, if at the EGM, 100 shareholders turn up, right? To get the scheme approved, you must have at least 51 of them voting for the scheme, because majority in numbers. And that 51 persons who attended and voted for the scheme must represent at least 75% of the shares that were present and voting. So if let's say 100 of you hold X percent, because not everybody turns up, I do not know why, but that's the rule, right? Of course, they got to seek court approval and all that stuff, but basically, the most critical moment is at the general meeting when shareholders vote. And of course, they will have very powerful PR machinery out there telling you, "Oh, this is the last vote. If you miss it, that's it." And then, in the capital markets, you have this what they call FOMO, fear of missing out. Hokkien call kiasu. Say, I don't want to lose out. I better take it, no matter how poor it is. And I understand, because each of you have different investment horizon. Each of you have different nest egg savings. Each of you have different expectations. I take the money now. I have different needs. The guy is rich, he can afford to fight. I think I better take whatever is given to me, although you may have paid a huge sum earlier. But that's life. Okay, so I'll cover that later. Okay, privatization, as I've said, before July 21st, I think, people took advantage of a loophole in Section 215 of the Companies Act, where they formed a special purpose vehicle, right? The vehicle doesn't own any share. It was formed purely to do the takeover. But this takeover is orchestrated by controlling shareholders, their families, their concert parties, who may have already controlled 80% of the shares or even more, right? So if it's, they already hold 80% from all these friendly related party or concert party, they then need to make an offer only to acquire the remaining 20% of the company, right? Company A is a SPV. Company B is the target listed company. So for them to exercise compulsory acquisition, they only need to receive acceptance in respect of 18% of the shares, which is a very low threshold. So that's before the law was changed. But the law has recently been changed, 1st of July. Now, you can't do this. You can't circumvent, you can't take advantage of a regulatory loophole to squeeze out minority shareholders. So if you have people who are related to you, your relative, your spouse, parent, brother, sister, adopted son, whole share, then you are part of, you cannot count towards that 90%, right? Or people who are your so-called Alibaba, hey, you go and buy a share, I pay for you, you hold the share, cannot. Because if you lie on it and subsequently found to be having all this side arrangement or less than above board arrangement, then I think SIC will come down on you like a ton of bricks. So the law has been changed. So from 1st of July, the original loophole has been closed. And that took a long time. For many, many years, people were complaining to the regulators. But for whatever it is, the law has been changed, all right? Well, whether the offeror will exercise the right of compulsory acquisition, they usually indicate in the offer document that is intending to exercise, or they will not. For example, in Bousted Project's case, they said that they will not exercise compulsory acquisition. And I explain to you later if someone wants to know about it. Okay, so privatization via voluntary delisting. What is voluntary delisting? It means they will make a voluntary general offer, right, to acquire minority shareholding in the listed company, but the listed company must convene a general meeting to obtain shareholders' approval. So again, it's the same thing, majority of numbers present and voting, and at least 75% of the total shares held by the shareholders present and voting. So that's the threshold, right? And then SGX has a regulatory requirement. The exit offer must be fair and reasonable, okay? And the target must appoint an IFA whose opinion must be fair and reasonable, right? So I think in Bousted Project's case, SGX did not approve the delisting. They said, well, you know, your IFA didn't opine is fair and reasonable, so I give you time to comply. You got to do a compliance placement to restore the public float, because the public float dropped to below 10% because shareholders were scattered. They were not like what David had said, you know, you act with a united kind of spirit, because each and every one of you is very easy to divide and conquer. You all hold different block of shares, different investment horizon, different financial position. So they managed to get more than 90%. But because there was a rule in SGX listing rules, to delist, the offer must be fair and reasonable and so opined by the IFA. So that didn't happen for Bousted Project. Now I understand they have to do a compliance placement, meaning to say they got to restore the public float back to 10%. So privatization, I'm just setting out this again, do it via scheme of arrangement or loss of free float after a takeover. But loss of free float doesn't immediately mean they can exit from SGX. As I told you, SGX has a rule that the offer must be fair and reasonable, and the IFA must so opine. Okay, so recent exit offer, you see GK Gold, Golden Energy and Resources, Bousted Projects. You know, SIAS will tell shareholders, look, there are certain things which are not, you know, not properly explained, or the offer is not fair and reasonable. You know, or this offer is fair and reasonable because the IFA doesn't give you a technically complicated opinion, comparing all kinds of things, which even myself, I must confess, sometimes when I read some of the IFA reports also, I scratch my head because they come up with a lot of things just to arrive at the desired conclusion. It's like I already know I must conclude like that. So I will come up with all kinds of reasoning to arrive at the conclusion. Now that is something that SGX has fixed it, and I'll explain to you later. Okay? Okay, so beware of lowball offers. What should you do? Well, of course, a lot of things, although you understand, and I think it's good that you understand, at times, sometimes it's also because you all are scattered, you are small, you don't have a collective voice. You may not have your voice heard. Well, SIAS has tried on a number of occasions when we think that the offer was not reasonable, not fair, we have spoken out. And as David Gerald has said, we had succeeded in persuading Bousted to increase their offer. We have succeeded in asking Lian Beng to increase, so on and so forth. But there's a limit to what we can do. Okay, but before that, let me take you through what are the recent regulatory changes that are imposed on the board when they appoint an IFA, and what the IFA must do They must access their own independence and what they must also say to in their reasoning and in their methodology, right? When they opine, and not just simply say, "Now, this is what I have to conclude. That's how I'm going to reason out and arrive at that conclusion." Now there is a regulatory safeguard to some extent, but ultimately it's back to you guys to accept or not to accept, to vote for or not to, or to vote against. Well, this is the guidelines which I said, now it's been crystallized as a regulatory requirement. The IFA must be independent, able to give independent advice. The directors must review the suitability of the IFA, whether they have the appropriate and relevant experience, whether there's information that casts doubts on their competency, the quality of advice and resourcing. This is something that is not so simple to comply if you have been tardy or you, in Hokkien call very chin chai, you can't do that now. You have to follow this very carefully. And the factors that the directors must take into account. Listed company must provide IFA with all information that the IFA requires. You have to ensure that valuation reports, expert reports, financial reports contain all the necessary disclosures for the IFA. Directors should also know that the IFA face a tight timeline, so they got to make sure that they fully cooperate the IFA. And then you got the directors themselves. You cannot just say, IFA say what I just say. You have to carefully assess the content and material consideration in the IFA's opinion. So you cannot just rubber stamp what the IFA says. Okay, so these are some of the regulatory improvements that the market regulators have put in place. And I can say this is through various consultation process that SIAS had with the regulators that led to this today. Otherwise, it was something that people had concerns that the IFA was basically, in some cases, the perception, whether correctly or incorrectly, they were just hired to give the go-through motion to come up with the, the fair and reasonable opinion. And I think a lot is now emphasized on the independence of the IFA, and that if you have a business, professional, or prior relationship or financial interest, either with the offeror or the controlling shareholder of the offeror, then it will erode your independence and thus affect your ability to render an unbiased opinion. So in such a situation, the IFA has to withdraw itself because it says it's no longer independent, right? And guidelines on what the IFA has to say or what they have to do, these are all done. It has to make sure that they explain the factors and grounds for forming the opinion. They have to disclose their methodology and also whether there's any relationship that can be relevant to their independence as an IFA, and that they should justify the choice of methodology and describe the methods used in the IFA opinion. IFA must consider following when evaluating a proposed takeover. Use more than one methodology as far as possible. You cannot just have one and then hum-thumb the thing in and arrive at the desired conclusion. You got to look at figures, can compare from different methodologies and comment on the differences. And then you rely your reliance and the basis of your reliance on certain factors and methodology. And you have to make reasonable assumptions and key assumptions. If there are discrepancies in the information or you have doubt as to the accuracy of the information provided by the company or provided by the offeror, then you should consider if it's reasonable and safe to rely on this information on which your evaluation is based. So you see, now there are a lot of guardrails. It's not you suka say what and then, I'm going a bit of a colloquial English so that I can, sort of cut eyes with most of you. I see are basically local retail investors. Pardon me if I don't speak English, but I'm not George Goh. I hope that it's a bit of a joke. Okay, so exit offers. So, well, there are also guidelines, okay? What is fair? What is reasonable? How can you have fair, not fair, but reasonable? So now SGX has set out some guidelines and codified that in the regulators column. An offer is fair if the value of the offer price is more than or equal to the value of the security subject to the offer. So what does that mean? It means that if the market price is close to your offer price, or your offer price is higher than the market price, now that seems fair. Now, this is not the be-all and end-all, but there has to be some minimum guideline. Okay, next thing, reasonable. So when you consider the reasonableness of the offer, you must not just look at the value based on the offer price. You have to look at things like, the voting power or the shareholding control of the offeror and its concert parties. Any other significant blocks of shares that are being held by people who are related. So if someone really controls 85%, then of course, the likelihood of them making an offer that reflects or is commensurate with their shareholding control is a factor in considering whether the offer is reasonable. Market liquidity, if there's hardly any trading, no trading at all, is that something that the IFA should consider? They should consider now, okay? And then if there's any alternative offer, likelihood of it being made by some other people. So these are all guardrails. In other words, now, when the IFA renders its report, it can be subject to question and queries, not just by people like you, but by SGX, or by SIC, or by SIAS even, or the media. In fact, now I think we have a lot of active media, persons who write in Hot Lock Seal, Business Times, commentaries that this is a lousy offer, this is taking advantage, exploiting minority shareholders. But now you have guidelines. So when you want to critique or you want to criticize, they say this opinion is rubbish. No, so you got now point by point. Have you looked at all these things? Have you considered all these things? So it's an improvement, but it's not an absolute protection to you guys. Right? Later I'll explain. So as I've said, these are the 4 potential outcomes in the fair and reasonable opinion. Fair but not reasonable, SIC normally would not accept it, and that under this approach is, of course, it's possible for the IFA to recommend to shareholders to accept the offer, even if the IFA is of the opinion the offer price is at a discount. Now, usually happens when there are other factors linked. For example, the shares are illiquid, and this is really an exit opportunity for all of you, right? The regulators column that was published on IFA is not just for takeover and exit offer. They also talk about really interested persons transaction. You have seen from time to time people do related party transactions or interested person transactions to benefit the people in control, to your prejudice, to your disadvantage. So now there are guidelines, because when you have an interested person's transactions called IPT, which is governed by Chapter 9 of the listing rules, the IFA has to make an opinion, give an opinion, and now there are guidelines as to what they must say. All right? And one of the important principles that is expected of the IFA is that they have to provide comparisons with arm's length transactions of third parties in the relevant market. If the relevant market is able to offer a better price, why do you opine and recommend that this particular transaction that involves an interested person is acceptable or fair and reasonable and not prejudicial to the interests of minority shareholders, right? So what are the factors that the IFA has to consider in a situation of an IPT? Whether is it prejudicial to the interests of the company and its minority shareholders, rationale and benefit of the transaction, value of the consideration, and the rate of discount, if there's any discount, vis-a-vis third-party transactions or third-party possible offers, financial situation and solvency. For example, if the company is dying, and there's one controlling shareholder who is prepared to buy over a certain asset of the company so that the company has funds to continue operations. I think these are factors that the IFA has to consider. Whether there's any preferential or selective treatment, I think that's very important, because when you have a rule and a requirement set out in the rule book, then you make sure you comply, because otherwise people can really find fault with your opinion and question your integrity, not just on your reliability of your opinion, but your integrity as an IFA, your market reputation. Now, of course, liquidity, as I've said, the company shares, if they're, and there's any special value of the transaction to the issuer. For example, in exchange for a certain sale to someone who is related to the company, and that person has extended a huge loan and says that, well, if you sell me this, I'll write off 10 million from your debts. And I think these are factors the IFA can reasonably consider, because at the end of the day, it's important. It must not be prejudicial to the interests of the company and the minority shareholders. Okay, so I've come to an end of my presentation. I welcome questions, so you can, I think there's a way you can scan your questions. Thank you. Actually, I prefer the old method. Just raise your hand and ask question. Can a nominee company still hold and not return the scrip of a delisted company to shareholders in custody? And withhold any information like HM gathering? Okay, Mr. Sim, right? Sim Cho Chai, right? I think what you are trying to say is that if the company is delisted and you are still a shareholder, can they withhold information? The short answer is no. You still have rights as shareholders. But, if you hold 0.00001%, that kind of shareholding, and if the company is oppressive, the company does things which write roughshod over your rights, then you're going to factor in what should you do to reinstate or restore your rights. It's not simple. If the company is a multi-million-dollar company, the controlling shareholder who has delisted the company is a conglomerate, a very powerful shareholder, and then you only hold, let's say, 10,000 shares. Now, would you want to, fight it out with them? I mean, that's, unfortunately, in Singapore, the stock market is retail-driven. Mom and pop investors, majority of people who put their CPF, their retirement funds. And if I can sum up the, I may be generalizing, people buy on hope, hold in greed, and sell in fear. so that's, a psyche which controlling shareholders understand. And then therefore, play up the FOMO, fear of missing out. And of course, in such a situation, I'm gonna just holding 10,000 shares, and then they might do a lot of things like stock split, or consolidation of shares. And at the end of the day, your 10,000 shares might be only left 100 shares, for example, and it's 0. whatever. Yeah, you still have rights. But what can you do? Complain to ACRA, write to ACRA? Yes, technically the provisions are there. Shareholders, the company has to give you conduct AGM, give you the audited financial accounts. Of course, you can question. But you see, unlike US, a lot of the shareholders are institutional shareholders. They can take you on. They have the money to fight you to the end of the world. And say, yeah, you better come down and settle. If not, I will sue you until your pants drop. So, and shareholder activism is not just making noise through SIAS. They really have the financial power to, to paralyze you, to take out injunction and block you. and really make life miserable for you unless you say, okay, now you settle with us. You see, so in a retail-driven kind of situation, it may not be in your best interest to spend another couple of 100,000 to hire lawyers to fight it out for something that you probably invested at 20, 30,000, which is a lot. It's not a small amount, but that's the reality. And I can tell you that while SIAS try our best to voice out, to call out, or to take umbrage, so to speak, but at the end of the day, it's up to you to decide whether you want to accept or not. Likewise for SIC, Securities Industry Council, they cannot say, no, this offer no good, go and increase it. They can't. So long as they have set the rules, they have improved on it, like the regulators column on IFA, they cannot make a commercial, they cannot interfere with a commercial transaction, meaning an offer and acceptance. They can only tell you that certain things have to be complied, which is now quite onerous. If I were an IFA, I have to think very carefully if I want to be biased towards the offeror because he promised me something. After that, you do all my capital market work in all this. I have to think twice because you could have whistleblowers. You could have people few months down the road, if you have a disgruntled employee who has taken photograph or video and said that actually my boss in this company, he did strike a private deal with so and so, then you had it. So in today's internet age, coupled with Singapore's reputation of being very unfeeling and cold, well, not exactly like Bao Jing Tian, but you have rules which basically no one is immune. And CAD or CIP, CPIB calls you up, and if an IFA is having some private arrangement with an offeror or someone close to the offeror, that could amount to corruption. You know what I mean? So well, I'm talking about topical issues of the day. Okay, let's look at the next question. How does the company conclude what method to adopt for privatization? Well, it depends. In a scheme of arrangement, it's all or nothing. They don't have the problem of having to increase their share price when shares make noise. They say, look, let shareholders decide. And the D-Day is the day where they convene the EGM for they call it the scheme meeting, where shareholders, the threshold is, as I've said, 100 of you turn up, at least 51 of you vote in favor. And then if 100 of you hold, let's say 20%, right, of the issued shares, then that 51 of you who voted for must hold collectively 75% of that block of shares, that percentage of shares, 20%. Yeah? So it's an all for nothing. And general offer basically is, as I've said, they have already garnered a certain block of shares and they are testing the market, come out with a low ball, see if they can get away with it, and then slowly up it or stick to their dig their toes in and stick to their offer, or give you just a little crumbs, big crumbs to sweeten the offer. So it's a decision that's taken by the offeror, not so much by the listed company. The board of directors in such a situation is more like a passive office bearer to do what is required of them when they receive a scheme document. They have to appoint an IFA, or if they receive a takeover offer, and then they're going to appoint an IFA, come out with an offeree circular. So it's not the listed company that concludes, it's the offeror based on its peculiar situation. It's shareholding blocks and all that. In case of Manulife, where financial covenant is breached, the sponsor is exploring potential alternative method and disposition mandate. May I know what's your take about it? Well, I generally in such seminars don't give my opinion on peculiar transactions because it's sensitive. So and I suggest that if you are a unit holder of a REIT and you think that there's something that could potentially be a breach, and the sponsor needs to do something, or the REIT manager needs to do something, or the trustee, then I suggest you consult your legal advisor, because in such a forum, I don't give an opinion. Sorry? I'm not sure what it means by that. Yeah, I'm not sure. I'm just saying that it's exploring potential alternatives. Perhaps the person who asked the question, who is anonymous, would you like to explain? I'm not sure what you mean by disposition mandate. But if you don't want and you want to talk to me privately, fair enough. But I don't quite understand. But what I'm saying is that they are asking my opinion, my take on that. Exploring alternative method and disposition. I suppose you're talking about disposals or what? I'm not sure. But again, let me say that I don't give opinion on peculiar transactions on a name basis. Yeah, unless it's public news. Here, can we have the next? What happens to bondholders when a company is delisted? Well, bondholders are basically creditors, right? So it's not a situation where so you have a loan, a right to recover your creditors, or whether there is a trustee is supposed to be appointed to take care of your rights. But again, as I've seen in many cases, trustees are not really that active institutions that will take up cudgels for you, because you have to fund them. Their mandate is that every year they take a certain fee for being the so-called trustee. But when they want to take up cudgels, I think it's a different thing. They will say, well, do you have enough to fund the legal suit? And I think not many trustees I've seen in recent years or even ever that they sue against the company and all that. So what happens? You remain a creditor. You remain a creditor. You have a right, but is the company insolvent? Because if the company is insolvent, like in High Flux, I think there are a lot of prefs and all kinds of bondholders. You rank very low in the recovery. Maybe you could have the next question. Who is SIC? I said at the outset, the SIC is called the Securities Industry Council. It is a division under the MAS. Very powerful, because when SIC investigates, they carry the same powers like the MAS. They are basically the guardians of a takeover, guardians of scheme of arrangement, and their rules are, while they are not written like a statute, they have wide interpretive powers. And anyone who runs contrary to SIC's direction will be tied, because they can convene an inquiry, name and shame you, and disenfranchise you from using the capital market. It's happened before. People who have breached the takeover code, they can suspend you from being a director for X number of years. They can order, in a very extreme situation, no banks will deal with you. Yeah. Well, I think you have read it in a case like years ago. I was involved in it, 2001. You have heard of Serial System? A guy called Eddie Cheng, he breached the takeover code. I think he was disenfranchised for a number of years. It's in the SIC's website. Well, I mean, there are also other people who have infringed, even professionals who wrongly advise on a takeover. They are name and shame. OSIM, if you look at OSIM, you look at this company called DeLong, I think. DeLong, DELONG. I mean, I'm trying to recollect, but you can find this on the website of SIC. What can shares be allowed to be, when can shares be allowed to be consolidated? Does minority shareholders have a say? Well, you can have a consolidation only if you vote for it, right? But you see, in a situation where, for example, a company subscribes for new shares, but doesn't want to mount a takeover and they have a whitewash, meaning to say minority shareholders and SIC bless and say that they don't need to do a takeover. Normally in a whitewash situation, when someone inject capital, new capital into the company, they don't want to have such a large float. So they will consolidate. Let's say every 100 share becomes 1 share. But that's subject to shareholders' approval. But mind you, if they already hold or they already have certain arrangement with controlling shareholders in the company now, in exchange for me rescuing your company, you better, bloody hell, you better vote for it. Then, if that person controls, let's say even 40% of the voting rights, how many of you can fight that collectively? Even, I think, if the public float is, let's say, 15%, collectively you already lose. So consolidation, normally the persons who want to do this, right, they will have calculated their numbers, and will likely know that if they get the undertaking to vote by existing controlling shareholder in exchange for rescuing their company, they are likely to secure the vote. Will a company pay for IFA for a fee to issue the report who ensure their independence? Well, that's been addressed in the guidelines which I earlier said. What happens is that who appoints the IFA? Directors in the listed company who are independent of the offer. All right, independent. Normally you look at the independent directors, but there could be 1 or 2 directors who are independent of means I have nothing to do with you. I was appointed historically because I'm a non-executive director. So if the family wants to mount a takeover, I'm independent of her. So it is the target company, the listed company that pays for the IFA. But you see, there were certain concerns that for the IFA, at the end of the day, you are only paid after the deal is over. And then the new offeror comes and control the company. Probably the directors who appoint you may then disappear with a blink of the eye. So there were concerns raised in the past, but now under the new guidelines, this would be an issue that people can take, can raise and query you. If there's indeed any evidence that you had a private handshake, and have certain arrangements whereby you compromise your independence or integrity. I mean, nowadays with video, my God, you can't really hide. So be nice to your employees. I have only 1 minute left. So that's my timekeeper. For delisted company, bondholders and companies still operating in solvent with bond conditions continue to be renegotiated. Well, you don't have to renegotiate if the company is solvent and still operating. Why must you? It's the fact that it may be delisted, but the company is delisted and it's solvent and operational. Means the controlling shareholders who want to take it private, want to enjoy all the profit, future profit, then you don't need to worry because it's not indebted, it's not going belly up. So there's no need to renegotiate your terms. Not at all. Yeah. So of course your bonds may be delisted, but again you remain a creditor. Well, maybe one last question to wrap things up. Yes? Anything about RTOs? RTOs is basically a situation whereby for a company that's a shell or it's insolvent or its existing or its previous business is no longer viable, someone wants to inject a new business into it, right? In exchange for shares, new shares. Now, this is a situation where I say that it is a whitewash is required because I'm injecting something into the company in exchange for shares. Otherwise, the company will dissolve. You guys don't get a dime. So, whitewash SIC is likely to grant, but is ain't subject to shareholders' approval. You need to have an IFA, all right? Again, so all the rules apply as well. So the IFA has to look at the thing that you are injecting into. Is it fair or is it some rubbish? some nonsense that you inject just to get control. Now, I think the IFA has a lot of, guidelines to observe and comply. And you as shareholders, you have to decide. Do you want to go with this new business? I mean, in the past, people inject nonsense, things like, coal mine, don't know, in Timbuktu or where else, or in a remote area in Indonesia, and 99%, most of them just disappear and go into thin air. But at least the market is still alive. There could be an opportunity whereby the shares start trading and people get excited. Perhaps that's the point that you want to sell your shares. Right? Rather than the company goes bankrupt, belly up, and you get nothing, right? So RTO, that in essence, that's RTO. After loss of free flow, the company send any sector on time to be delisted. Yeah, all this will be announced. There'll be announcements made. There'll be publications taken on Business Times, Straits Times. I think we perhaps even lend her Chao Pao to say that this is a timeline. You better, accept. If not, you'll remain in a private company. And in a private company, one thing is this. It's no longer subject to SGX scrutiny. They don't have independent directors. They don't have audit committee anymore. So as I've said, you are a lone ranger against the people who might just strip the company bare and leave you with a shell. And then for you to, engage lawyers and fight it out. But, you have to consider if that's worth your while. I've come to the end, the timekeeper, so it says overrun. So, oh my God, my time is up. Thank you very much.